I usually do these short bits in the newsroom studio, but it's tied up. I hope with some hot breaking news. We'll let you know about that soon. But in my office now, and isn't it wonderful? On today's show, we'll take a look at a very polluted part of the country, one of the most polluted parts of the country, right here in New Mexico, the Four Corners area, and how a U.S. Supreme Court decision just might change that. Another report on the county planning process from our reporter, Marion Cox. And our top story, they're beginning debate. It hadn't happened yet by the time this program began, but the state legislature is looking into a domestic partners bill. We'll get arguments on both sides. Stay tuned for that right after this video. Claims and counterclaims. That's what's been leading the debate over domestic partnership legislation to be considered by New Mexico lawmakers. It comes up before the state Senate, possibly shortly. First, the claim. A group of Republican state lawmakers contend that if the state legislature passes domestic partner legislation, it would amount to more than just extending to unmarried couples the same benefits now enjoyed by married couples. They say it would automatically lead to actual marriage. Austin Nemox, a lawyer with the Alliance Defense Fund, explained that point of view earlier this week.
Senate Bill 12 is a very dangerous bill because it seeks to legislatively impose same-sex marriage in New Mexico. We have seen this as a national organization in other states like California and Connecticut, where similar bills have subsequently been used to impose same-sex marriage through the high courts of that state. More specifically, Senate Bill 12 has a reciprocity provision in it, which specifically states that same-sex marriage licenses from other jurisdictions will be deemed valid in the state of New Mexico. This bill, by its very language, seeks to impose same-sex marriage legislatively in New Mexico. If New Mexicans understand what this bill chooses to do, we urge them to reject it and same-sex marriage as legislatively enacted by the legislature.
Well, what about that claim? The counterclaim comes from the ACLU. I spoke with Ken Chu, who's a lawyer in the National ACLU office, to ask about what the Republicans contend.
Well, it's simply false that the Supreme Courts in Connecticut and California held that domestic partnership is the equivalent of marriage. That simply is not a part of those rulings. In fact, those rulings were based on the state constitutions of those states, not on the domestic partnership legislation in those states. And the analysis under the Constitution would have been the same regardless of whether there was legislation in those states.
Well, this is a confusing issue. Can you bring us up to date? What did the state law in California say? And then what did the Supreme Court say after that?
In California, there was comprehensive domestic partnerships. The California Supreme Court in the marriage case ruled that to exclude same-sex couples from marriage was a violation of the fundamental right to marry. In addition, the California Supreme Court ruled that it was a violation of equal protection to exclude gay and lesbian couples from marriage. Those two constitutional rulings did not turn on whether there was or was not legislation in those states granting domestic partnerships.
So did the Supreme Court there throw away the domestic partnership legislation, rule it invalid?
Well, not as invalid, but as not sufficient to ensure equality under the law for gay and lesbian couples and their families. And so in California, the court certainly recognized that there were rights that were afforded to gay and lesbian couples and their families by the domestic partnership law, but said that they were not sufficient under the Constitution to ensure equality. And so that's why the court went on to say the Constitution requires equality, and so therefore marriage must be extended to gay and lesbian couples.
Now, we talk about gay and lesbian couples and domestic partnerships. Doesn't it also apply to heterosexual couples as well?
Well, yes, the domestic partnership law certainly does apply to opposite-sex couples as well. But, of course, the marriage rulings that we were discussing in California and Connecticut were about the right of the same-sex couples to marry.
Do I understand correctly there were some states and still are some states where domestic partnerships are allowed, but that same-sex couples are not allowed to actually marry?
That's correct. There are 7 states that have domestic partnerships or the equivalent by legislation, and in those states, same-sex couples may not marry. So it is not true that where there is domestic partnership or its equivalent, that inexorably leads to marriage. In fact, in 2 states, New Jersey and Washington State, the state Supreme Courts held that despite the fact that there was domestic partnership or its equivalent in the state, there was no constitutional mandate to extend marriage to same-sex couples.
All very confusing, and I think the public is terribly confused about this. Anything else we should know to keep a good focus on this issue?
Well, it's really not that confusing. I think, everyone understands as a matter of common sense that domestic partnership is not the same as marriage. The fact that in these court cases, one has not necessarily led to the other only confirms that.
Ken Chu of the National ACLU.